The agency that gun owners have been fighting for decades just lost, and it lost big, it lost broadly, and it lost in a way that permanently limits the Bureau of Alcohol, Tobacco, Firearms, and Explosives Authority to regulate civilian firearms in America. June 25, 2026. The Supreme Court issued its opinion in National Firearms Commerce Alliance versus ATF, a case that consolidated 6 separate challenges to 6 separate ATF regulatory actions into a single comprehensive ruling that 6 justices agreed must go against the agency and in favor of law-abiding gun owners, manufacturers, and dealers across all 50 states. In a 6-justice majority opinion authored by Justice Clarence Thomas, the court strikes down ATF's frame and receiver final rule, ATF's engaged in the business redefinition, ATF's authority to revoke FFL licenses for administrative errors, ATF's Form 473 marijuana question, ATF's ability to create new criminal categories through regulatory redefinition, and ATF's inspection framework as applied to compliant FFLs. Every gun owner in every state is affected. Every licensed dealer in every state is protected. And the agency that has spent decades expanding its regulatory authority beyond what Congress ever authorized has been told, in the clearest possible terms, that its days of legislative action through regulatory redefinition are over. Subscribe right now because National Firearms Commerce Alliance versus ATF changes things that directly affect every gun owner who has ever bought a firearm from a dealer, every dealer who has ever been inspected by the ATF, every manufacturer who has ever received an ATF determination letter, and every person who has ever wondered whether their legal activities were about to become criminal by regulatory redefinition. And the answer from 6 Supreme Court justices is that the ATF cannot do what it has been doing. It never had the authority. And every person affected by its unauthorized regulations is entitled to immediate relief. The National Firearms Commerce Alliance, a coalition of manufacturers, dealers, distributors, and individual gun owners, filed a comprehensive challenge in the Northern District of Texas in January 2026, consolidating 6 separate pending challenges to 6 ATF regulatory actions. The choice of the Northern District of Texas was deliberate. That court has jurisdiction over many ATF regulatory challenges. Its judges have demonstrated willingness to examine ATF regulatory authority carefully, and the consolidation allowed the alliance to present a systematic picture of ATF overreach across multiple regulatory areas simultaneously rather than winning one case while losing another in a different circuit. Judge Mark Pittman, who had already issued preliminary injunctions in multiple ATF regulatory challenges, the pistol brace rule, the ghost gun frame and receiver rule, and others, was assigned the case and moved it through an accelerated schedule that reflected the constitutional urgency of the consolidated claims. The Fifth Circuit affirmed Judge Pittman's comprehensive ruling, striking down all 6 regulatory actions. The Supreme Court granted certiorari and affirmed, with Justice Thomas writing for a 6-justice majority, that built directly on West Virginia versus EPA's Major Questions Doctrine, Garland versus Cargill's textual analysis of ATF authority, and the court's broader administrative law framework for evaluating agency regulatory claims. The decision was issued June 25, 2026, just weeks after the cascade of other major Second Amendment decisions that have defined the legal landscape for gun ownership in America, and it addresses the regulatory side of the equation that prior Second Amendment decisions had left partially open. Number 1, the first 2 ATF defeats, the frame and receiver rule and the engaged in business redefinition. ATF Defeat 1, the Frame and Receiver Final Rule, 2022 struck down. ATF's 2022 Frame and Receiver Final Rule attempted to redefine what constitutes a firearm under the Gun Control Act to include unfinished frames and receivers that are not yet functional weapons. The statute's plain text definition is clear. A firearm is any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. An 80% lower receiver that cannot expel a projectile is not designed to expel a projectile and cannot without significant machining be readily converted to expel a projectile is not a firearm under the statutory text. Justice Thomas writes, Congress defined firearm precisely in 1968. It did not define potential firearm or unfinished firearm. ATF cannot add a modifier to a statutory term that contains no such modifier. Doing so is not a permissible interpretation. It is legislative action requiring an act of Congress not an agency rule. Every 80% lower receiver, every unfinished pistol frame, every firearm building kit covered by the 2022 rule is no longer covered by ATF regulation. Manufacturers and sellers of these products do not need to serialize them, maintain records, or conduct background checks for their sale. The background check requirement for 80% products is void from the date of the Supreme Court's opinion. ATF Defeat 2. The Engaged in Business. Redefinition. ATF's 2024 rule, implementing the Bipartisan Safer Communities Act's expanded licensing requirement, redefined engaged in the business of dealing in firearms to include any person who predominantly sells firearms for profit, language that captured occasional private sellers, collectors disposing of collections, and individual gun owners selling personal firearms. The Trump administration had already rescinded this rule through administrative action, but the alliance challenged it at the constitutional level to ensure no future administration could reinstate it. The court agreed. Thomas writes, whether a private citizen must obtain a federal license to dispose of their personal property, including their firearms, is precisely the kind of question of major significance requiring clear congressional authorization. ATF's interpretation, extending the licensing requirement to occasional private sellers, went beyond what any reasonable reading of the statutory text authorized. The ruling restores the prior understanding. Only those whose primary livelihood involves purchasing and selling firearms for profit are required to obtain FFL and conduct background checks. Private sellers, occasional sellers, and collectors are not engaged in the business at the federal level. Number 2. The third and fourth ATF defeats. FFL revocation and Form 4473. ATF Defeat 3. License revocation for administrative errors. The Gun Control Act permits license revocation for willful violations of the Act's requirements. The Biden-era enhanced regulatory enforcement policy had treated any paperwork error as grounds for immediate revocation, eliminating the willful standard in practice. The Trump administration had administratively replaced this with the administrative action policy, but the alliance challenged it at the constitutional level to make the protection durable beyond any single administration's policy preferences. The court holds that willful has a specific legal meaning requiring knowledge that conduct is unlawful, combined with a choice to proceed anyway. An FFL who makes a paperwork error and corrects it when identified has not acted willfully. Thomas writes, revoking a license for administrative errors that do not meet the willful standard deprives a licensee of their livelihood and constitutional rights without due process of law. ATF cannot revoke FFL licenses for administrative errors that do not meet the standard of willful violation, and this protection is now constitutionally mandated, not merely administrative policy. Every FFL that received a revocation under the Biden-era zero-tolerance policy for administrative errors can challenge that revocation as legally void under National Firearms Commerce Alliance. Dealers who lost licenses based on paperwork errors have grounds for restoration through Section 1983, Civil Rights Claims and Administrative Appeals. ATF Defeat 4, Form 4473, and the Fifth Amendment. ATF's Form 4473, Question 21.f, asks whether the purchaser is an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. This forces a purchaser who uses marijuana, even in a state where marijuana is legal, to choose between two options with criminal consequences. Admit marijuana use, which triggers denial under 18 U.S.C. Section 922 G. 3, is prohibition on unlawful drug users possessing firearms, or deny marijuana use, which constitutes making a false statement on a federal form in violation of 18 U.S.C. Section 922 A. 6, punishable by up to 10 years in prison. 6 justices agreed that forcing a person to choose between self-incrimination and a felony false statement violates the Fifth Amendment. Thomas writes, a TF cannot require a purchaser to answer a question about their marijuana use as a condition of exercising Second Amendment rights where the answer in one direction triggers federal prohibition and the answer in the other direction constitutes a felony. Question 21.f must be amended or replaced with a constitutionally compliant alternative. In the 40-plus states where recreational or medical marijuana is legal, Millions of people have been in this Fifth Amendment trap every time they attempted to purchase a firearm. National Firearms Commerce Alliance removes that trap. Dealers who receive acknowledgments of state legal marijuana use cannot use those responses as grounds for denial during the period between the court's opinion and ATF's revised form. Number 3. The fifth and sixth ATF defeats: inspection authority and criminal liability creation. ATF defeat 5. Inspection authority limits. ATF's inspection program had expanded into what effectively amounted to continuous surveillance of compliant FFLs, inspections lasting days or weeks, demanding access to records beyond GCA requirements, involving physical surveillance of dealer premises and designed to generate revocation grounds rather than ensure compliance. Thomas writes, Congress authorized ATF to inspect for compliance. It did not authorize ATF to establish continuous surveillance relationships with licensed dealers, to conduct multi-day investigative inspections, or to use the inspection program as a mechanism for generating revocation grounds against dealers who have committed no willful violation. An inspection program that exists to generate prosecution leads, rather than to identify and correct compliance issues, is not the compliance inspection program Congress authorized. ATF's inspection authority is limited to what is necessary to ensure compliance, periodic compliance checks of reasonable scope and duration, and does not extend to extended investigative inspections designed to find grounds for revocation. The practical implementation of this holding requires dealers to understand what a lawfully scoped ATF inspection looks like: arrival with identified agents, statement of the inspection's scope and purpose, review of bound books and required records for the compliance period being inspected, and departure upon completion of compliance review. An inspection that extends to reviewing communications, conducting extended customer interviews, examining premises for compliance with physical requirements beyond ATF's GCA-derived authority, or continuing beyond the records review to investigate potential criminal activity beyond compliance failures. All of these exceed the authorized scope. An FFL subjected to an inspection exceeding reasonable compliance assurance scope can request that the inspection be limited to authorized scope, seek an emergency court order limiting the inspection scope, and file a contemporaneous protest establishing they are not waiving their right to challenge the inspection scope. ATF defeat 6. No criminality through rulemaking. The most significant long-term holding in National Firearms Commerce Alliance is what Thomas calls the no criminality through rulemaking principle. ATF had attempted, through its frame and receiver rule, bump stock rule, and pistol brace rule, to create criminal liability for conduct not criminal under the statutory text Congress enacted. Thomas writes, Congress, and only Congress, has the authority to define criminal conduct. When ATF's regulatory redefinition of machine gun captures bump stock-equipped semi-automatic rifles that Congress did not define as machine guns, ATF is not interpreting criminal law, it is writing it. The major questions doctrine, the non-delegation doctrine, and the constitutional command that criminal law be established by Congress all foreclose this approach. An agency can interpret the criminal categories Congress established. It cannot expand them. The difference between interpretation and expansion is not always easy to identify at the margins, but when ATF's interpretation captures millions of civilian products that were manufactured, sold, and possessed legally for years, it has plainly moved beyond interpretation into expansion. ATF cannot create new categories of criminal conduct through rulemaking. It can only interpret and enforce criminal categories that Congress has clearly established through statute. This principle, applied consistently in future ATF rulemaking challenges, prevents any future ATF regulatory action that effectively creates criminal liability for previously lawful conduct, whether by redefining covered items, redefining prohibited configurations, or redefining transaction types that had been unregulated. The principle provides the permanent constitutional limit on ATF's regulatory authority that prior decisions, which struck down specific ATF rules on specific grounds, could not establish as a general principle. Number 4. What this means for every gun owner, dealer, and manufacturer in all 50 states. Gun owners. Every firearm-related activity that was made criminal by one of the 6 void regulatory actions is now lawful again. Purchasing unfinished frames and receivers without background checks is lawful. Private sales without FFL involvement are restored to the pre-2024 understanding at the federal level, subject to state law. Possessing firearms purchased during periods when ATF's void rules were in effect creates no retroactive criminal liability. Void rules create no criminal liability from their inception. If you were charged with a crime based on one of the 6 void rules, contact a criminal defense attorney immediately about a motion to dismiss citing National Firearms Commerce Alliance. Licensed dealers. You have the constitutional right to limit ATF inspections to their authorized compliance assurance scope. The willful standard for license revocation is now constitutionally mandated. ATF cannot revoke your license for administrative errors that are not willful. If you lost your license under the Biden-era zero-tolerance policy based on administrative errors, contact a firearms law attorney about license restoration and Section 1983 damages. Going forward, every inspection you undergo is limited to compliance assurance, not investigative fishing expeditions designed to generate revocation grounds. Demand that ATF inspectors identify the scope and purpose of any inspection at its outset. If the inspection appears to exceed its authorized scope, if inspectors are reviewing communications, conducting extended customer interviews, or examining records beyond what bound book and required documentation compliance requires, document the excess scope and consult counsel about an emergency motion to limit the inspection. Manufacturers. The frame and receiver rule is void, eliminating serialization, record-keeping, and background check requirements for unfinished frames and receivers. The no criminality through rulemaking principle protects your manufacturing decisions from future regulatory redefinition unless Congress specifically authorizes the redefinition. ATF determination letters remain important for understanding the agency's current interpretations, but National Firearms Commerce Alliance establishes that those letters cannot create new criminal categories. They can only inform you of the agency's interpretation of existing criminal categories Congress established. If you received an adverse ATF determination letter that caused you to modify, discontinue, or abandon a product line based on ATF's regulatory redefinition of an existing statutory category, you may have civil rights damages claims for the period during which you operated under the void regulatory framework. Marijuana users in legal states. Dealers cannot deny your purchase based solely on acknowledgement of state legal marijuana use after the date of the court's opinion. ATF must revise Form 4473 to eliminate the marijuana question or provide a constitutional alternative. In the interim, consult with a firearms law attorney in your state about the practical implications for your specific situation. The broader question of whether Section 922(g)(3)'s prohibition on unlawful drug users possessing firearms is constitutional as applied to users of state legal marijuana was explicitly noted but not resolved by the court. It flagged the question as one requiring separate litigation. That litigation is already being organized, and the National Firearms Commerce Alliance holding creates favorable precedent for the broader constitutional challenge to Section 922(g)(3) as applied to legal marijuana users. Number 5, damages and the 3 justice dissent. Civil rights damages available. Citizens who suffered harm from the 6 void regulations may have Section 1983 civil rights claims against enforcing officials. For the frame and receiver rule, refund of fees paid for compliance services rendered void. For the engaged in business redefinition, damages for persons required to complete FFL transactions that should not have been required. For the license revocation standard, restored licenses and damages for dealers who lost licenses based on administrative errors, including lost business income during the revocation period. For Form 4473 marijuana question, damages for persons denied firearm purchases based solely on state legal marijuana use acknowledgement. Gun rights organizations, FPC, SAF, GOA, are publishing claim registration portals for all 6 categories of affected individuals and businesses. Class actions are being organized in all 50 states. The 3 justice dissent. Justice Sotomayor, joined by Kagan and Jackson, dissented from all 6 holdings. Her dissent argues that ATF's regulatory actions were reasonable interpretations of statutory authority Congress granted, and that the no criminality through rulemaking principle would paralyze the administrative state by preventing any agency from issuing rules with criminal consequences. She writes, almost every major federal regulatory regime has criminal penalties for violations. The Clean Air Act, Clean Water Act, Securities Regulation, Healthcare Regulation. Today's majority creates a constitutional rule requiring Congress to specifically authorize every criminal consequence in every regulatory action, a requirement Congress has never operated under. The dissent identifies real tension in the majority's analysis and its implications for administrative law beyond the gun context. What the 6-3 split means. National Firearms Commerce Alliance is decided 6-3, not 9-0. The three-justice dissent means that court composition changes could potentially threaten these holdings, particularly the no criminality through rulemaking principle, which the dissenters identified as having broad implications beyond ATF. Support the organizations that will defend these holdings against future challenges and remain engaged in the appointment processes that determine court composition. Bottom line, National Firearms Commerce Alliance versus ATF, June 25, 2026. 6-3. The ATF suffered 6 major defeats in a single Supreme Court opinion. 6 ATF defeats. Frame and receiver, final rule void. ATF cannot expand the firearm definition to include unfinished components. Congress did not define as firearms. Engaged in business redefinition void. Private sellers, occasional sellers, and collectors do not require FFL or background checks at federal level. FFL revocation for administrative errors void. Willful standard constitutionally mandated, administrative errors cannot trigger revocation. Form 4473. Marijuana question void. Fifth Amendment prohibits forcing purchasers to choose between self-incrimination and false statement felony. Inspection authority limited. Inspections limited to compliance assurance, not extended investigative fishing expeditions. No criminality through rulemaking. ATF cannot create new criminal categories through regulatory redefinition without clear congressional authorization. What you can do: move to dismiss any criminal charge based on void rules. Pursue FFL restoration and damages if license was revoked for administrative errors. Register with FPC, SAF, GOA class action portals if you suffered harm under any of the 6 void rules. Demand inspection scope clarity when ATF inspects your dealership. Consult firearms law attorney about marijuana question implications. Subscribe because National Firearms Commerce Alliance's 6 holdings are being implemented, litigated, and challenged simultaneously across all 50 states, and every development, ATF's compliance interpretations, lower court applications, class action progression, and state-level adjustments, directly affects gun owners, dealers, and manufacturers everywhere. 6 defeats. 1 day. 1 opinion. The ATF's authority over civilian firearms just got permanently defined, and defined much more narrowly than the agency has been operating.